All rise.
Please be seated.
The Kosovo Specialist Chambers is now in session.
Good morning and welcome to the first trial preparation conference in this case. I will now give the opportunity for the photographer to take some pictures. Please proceed. Thank you. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-04, the Specialist Prosecutor versus Pjetër, Shala.
Thank you, Madam Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules we have to observe at all times. So, please, before speaking, make sure you activate your microphone and you switch it off when you have finished with what you have to say. We have interpretation from Albanian into Serbian, so please speak slowly and clearly. And before intervening, wait 5 seconds in order to allow the interpreters to finish the interpretation of the previous sentence. And this is a hard one. So please wait, and then, because if not, we have overlapping speakers, and that's really problematic. I would also like to remind the parties and the Victims' Counsel and the registry that certain information in this case is subject to protective measures and confidentiality orders. This confidential information shall not be disclosed in open session, and I remind you to give me prior notice should any submission require to go, should require the disclosure of confidential information, then we can go into private or closed session. Very well. I would kindly ask the parties, Victims' Counsel, and the registry to introduce themselves, and we start with the Specialist Prosecutor's Office. You have the floor.
Good morning, Your Honors. Today, the prosecution is represented by Alex Whiting, Deputy Specialist Prosecutor, Gaia Pergolo, Associate Prosecutor, Eva Wheeler, Associate Prosecutor, Daniel Mesei, our Case Manager, Giulia Bianchi, our legal intern, and myself, Filippo De Minicis, Associate Prosecutor.
Thank you, Mr. Prosecutor. Victims' Counsel, you have the floor.
Good morning, Your Honours. I'm Simon Laws. I'm Victims' Counsel.
Please activate your microphone.
Forgive me. Early mistake. Do forgive me. I'm Simon Laws. I'm Victims' Counsel in this case, and I'm joined today by my co-counsel, Maria Radziowska.
Thank you. Defense, you have the floor.
Thank you very much.
Could you activate your microphone, please?
So
We have to
I
get
made it, I'm sorry.
accustomed to it. It will work in some days,
Yes.
no
Okay.
doubt.
Thank you. I'm Mr. Jean-Louis Gélissin from the Bar of Liège. I'm a Belgian one, and I'm afraid a French-spoken person, but I made an effort in English sometime. And I am here with my co-counsel, Mr. Awini, the second co-counsel, Ms. Carrielou, and the case manager, Ms. Denetra Petrovica. We have the pleasure to have with us two interns from the Paris University from France, and the team is complete, I think so. Thank you very much.
And for the record, your client, Mr. Shala, is also present in the courtroom.
Yes, of course.
Yes.
Last but not least, Mr. Shala is with us. I hail him. Thank you very much.
Very well. Mr. Shala, I remind you that all rights under the law and the rules, as they were read to you by the pre-trial judge at your first appearance, continue to apply before this panel, including your right to remain silent. Now I turn to the registry. Please, you have the floor.
Good morning, Your Honours. Good morning, colleagues. Jonas Nilsson, Judicial Services Division, representing Registry today.
Thank you. And for the record, my colleagues are Judge Roland Deckerts, Judge Gilbert Biti, and Judge Vladimir Mikola. And my name is Mappi Veld-Volja, and I'm the presiding judge for Trial Panel 1. I will give a short procedural history to introduce today's hearing and to give the legal basis for it. The 28th of January of this year, the SPO submitted its pretrial brief. On the 29th of July of this year, the SPO amended its list of witnesses. It was again amended on the 10th of October and filed an amended list of exhibits. On the 5th of September, the defense filed its pretrial brief and sent us a provisional list of witnesses. Yes, I see you nodding. And we have had several decisions admitting in total 8 victims participating to the proceeding. And we will refer to them as victims 01/04 till 08/04. And on the 15th of September of this year, the president of the specialist chambers assigned Trial Panel 1 to the present case, upon transmission of the case filed by the pretrial judge. And that happened on the 21st of September of this year, when the pretrial judge transmitted the case file to Trial Panel 1. We issued as Trial Panel on the 30th of September a decision scheduling the trial preparation conferences on today, tomorrow, Thursday, and with reserve day Friday, including an ex parte closed session. And in that decision, we requested the parties, the Victims' Council and the Registry, to file written submissions on a number of issues with a view to gathering information to plan the next steps for the commencement of the trial. We have received your submissions on the 10th of October as requested, and we have granted to the defense, the 13th of October, a request for an ex parte hearing with the panel. And the correspondence dated 13th of October of this year, CRS PD 42 at 4:11, email from Trial Panel 1 to CMU regarding the defense ex parte decision. I mention it here because in that way we have put it on record and it's not somewhere in the system hidden. Let me now inform you of the purpose of today's hearing. Yeah. Today and the following days we will be sitting here in a session what the rules of procedure and evidence call the trial preparation conferences. These are hearings and I say this also for the public, where the trial panel shall discuss and gather all the information that is needed to start the trial. We will do that together with the SPO, the defense, the victims' counsel, and the registry. So therefore, today we will not discuss the guilt or innocence of the accused, nor will we examine any evidence. Regarding the schedule for the upcoming days, the panel notes that there has been a change with regard to tomorrow afternoon. Yeah. The panel will not sit tomorrow in the session from 2:30 till 4 o'clock. As announced in the decision scheduling the trial preparation conference, there will be an ex parte closed session with the SPO, the registry, including the Witness Protection and Support Office, and as already indicated, we will have an ex parte closed session with the defense. The agenda for today is as follows. We will first go through the list of the issues set out in the decision. You will be given the opportunity to make further observations, and we will have some questions on several topics. Yeah? You will be given also the possibility to make any points you deem necessary. And finally, we will issue a number of oral orders, and we will inform you of the decisions, some of the decisions the panel intends to issue in the upcoming period. Good. Now, before we start our discussion, I would kindly ask you to follow the agenda as set out in our decision and refrain, of course, as much as possible from repeating things that have already been submitted. Let me see. First point on the agenda. This was the investigations and the disclosure of evidence. Yeah, we requested submission from the Specialist Prosecutor's Office on the following issues. That was confirmation by the SPO that the investigation and the disclosure of incriminating evidence, in this case, have been completed. And we requested submissions on whether the SPO intends to disclose to defense further exculpatory evidence under Rule 103 of the rules, or further material evidence under Rule 102, paragraph 3 of the rules, and some related questions. Yes, before I will give you the floor to make further submissions, if any, Mr. Prosecutor, I would like to go into private session because we have to discuss something which was redacted in your filing. So, Madam Court Officer, could you bring us into a private session, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer.
Your Honor, it's my understanding that the documents mentioned in paragraph 12 of our submissions have in fact been disclosed last Friday. And I believe I could give you the disclosure package number. Which would be number 87.
And a further remark in this, thank you for your observation and for this information. And could it be further clarified why it was disclosed now and not at an earlier moment? I can imagine that that is a legitimate question from the side of the defense.
Yes, Your Honors. We have, at the end of, towards the end of the pretrial phase, and as we were moving towards the trial phase of the proceedings, we have decided to conduct an audit of our disclosure to capture any newly acquired document, but as well to make sure that we had in fact disclosed all the documents, we had fully complied with our obligations. And we found a limited number of documents, some of which, for example, became disclosable only as of recent, for example, with the addition of the witness in our witness list on the 29th of July. And these are, I would say, the bulk of the Rule 103 disclosure that we've just released. Other documents concern fairly recent communications with our witnesses. A small number of them we had been in possession for some time, but we had not captured them in our earlier disclosure exercises. I have to say that some of the information contained in these documents is, I would say that vast part of that is duplicative of information which was already known to the defense. For instance, was information that was conveyed to us by one of our witnesses during phone conversations that we had with the witness, and we have disclosed further notes of these conversations or information which was largely already known was also repeated. So for completeness, we have disclosed these documents. So to sum up, Your Honors, this Rule 103 disclosure exercise, it's a mix of documents that only as of recent that become disclosable under the rules, and other documents which we have found doing an audit exercise of our earlier disclosure.
Yes, thank you, Mr. Prosecutor. You mentioned some of the documents are related to a witness. Did you just said that?
Yes, Your Honor.
Yes.
If you want, I can give you a breakdown of the documents and their relevance, an update to our written submissions.
Yes, I see that you here refer to the additional witness on our on your witness list on the 29th of July.
That's correct.
Just without being too insistent, but that was end of July, and we are now talking about half of October. So the panel was just wondering why, taking into account that 2.5 months had passed by, it was disclosed now. That is, but you have said you have done an audit, and we just want to make the point that some time has passed before sharing it.
We understand the panel's concern, Your Honors. Thank you very much.
Is there something else you would like to add in regard to Rule 103?
To Rule 103, no, Your Honor. We have some updated numbers concerning the 102.3. If Your Honor would like to hear submissions on that.
Yes, very well. We have seen that you have identified 108 documents, potentially disclosable, and you request leave to include them in an updated Rule 102 paragraph 3 notice. This is paragraph 15 of the filing 303. And what we would like to hear from you, and I see that you already have some additional observations, what your additional observations are, and especially if you will require protective measures for any of more of the documents before disclosure. And after that, I will give the floor to the defense, because what I will do is I will give them the floor to react on both 103 and 102 paragraph 3, Defense Counsel. Then you can give your responses or your observations all at once.
Thank you, Your Honor. We have reduced the number that we had announced in our written submissions to 85 documents. We did that by screening out duplicates of the documents and by checking whether, in fact, some of these documents had already been disclosed because duplicates of others, and so the number is now 85. No request for protective measures will be necessary for any of the documents should the defense elect to request disclosure. And also, these documents, we have also found them further to the audit that we have recently completed.
Thank you, Mr. Prosecutor. Very well. Defense Counsel, you have the floor if you would like to respond.
Thank you very much, Your Honor. Your Honor, I cannot hide, of course, I'm a little bit, and I have to confess it, I have a discomfort with the position of the prosecutor. That's sure. That's sure. And I'm afraid that's part of a whole. I have the feeling that with some changings, with some wish to withdraw some witness, and particularly on this point to the will to add some document, and that's not new documents, of course. If it was new document, we are ready to talk about and to explain, to express our view, and even concern about that. But it is not new document. And I have a strong feeling and some bitter feeling about the way to continue this disclosure as if the pre-trial procedure was not over. And really, we have to face a lot of difficulty with that. Now it's time for the prosecution service, for the specialist prosecutor to understand we are in a trial, in a real one, not a pre-trial. And it could be, I consider it could be unfair to oblige us to work on moving sand, because we are working on moving sand. We start our investigations on the basis of the document we received. And you know exactly what is the difficulty to receive some document, particularly at this stage of the proceeding. We have to receive it, we have to read it, we have to analyze it, we have some time to translate it, to be able to make the analysis with Mr. Shala himself, and try, of course, to make the best decision of what we consider, right or wrong, the best answer. Sometime, no problem. I have to say, sometime, no problem. But in the past, we know that we met a lot of difficulties. I have to remember all the people here that almost 500 documents were lost and provided to the defense very late. We have a big and huge difficulty with the way that some documents were presented, and we lost a lot of time. All of us, the pre-trial judge, lost a lot of time. And I'm afraid that we are now, if I understand well, and I am afraid I understand very well, in the continuation of the situation. Sometimes I say there is no problem, no issue. Sometimes we are obliged to go on the ground to make some investigation with the new information. And sometimes that's worst. We are obliged to reread some documents with the new enlightenment. issued by the so-called new document. So really, I think, and I sustain respectfully, now it's enough. You have to draw a line. I consider that with this new situation from a procedural point of view, we have to consider that the deadline is gone. We are in such situation that's enough. What is a trial? What is a trial? It cannot be a trap. It cannot resemble to an ambush. I don't say this is the wish of the prosecutor, of course. I want to be very clear. But it could look like, even without intention. I told you we have the feeling we are walking on moving sand and waste a lot of energy, a lot of means on some reading of documents, on some investigation which we have to restart. And may I say, take care, because if we have the feeling we are walking on moving sand, you could move on a swamp. That's all the difficulties. The prosecutor is the engine of the procedure. He is the one who decides to start to issue an indictment, to ask for the confirmation of the indictment, who asked for the arrest of Mr. Shala. He is detained now since 18 months. And we receive some day just before the start of this conference some documents, and it's not new documents. So I don't have to be longer, I think so. You understand perfectly well what is my uncomfort. And I just underline as a conclusion, I'm afraid that this part of the problem, this part of this issue, is just a part of a wall, of a hole, as I say, a hole, a real big issue that concerning, in reality, not the wish to catch the possibility to complete the evidence, but to change his mind, to change the reality of the case. So I think that I have nothing to add. Just one thing, with your permission. We issue a PTB, a pre-trial brief, I have to say. We were not obliged to issue it. And we make the choice to be clear, because our relation, and I want to focus on that and underline it, are very professional. It's a high-quality professional relationship. And we decided to be very clear and to explain exactly what is the position of the defense at this stage. And we have the feeling, perhaps a bad feeling, I hope so, that there is something new in the position of the prosecutor, in the prosecutor's position. That to change, I don't know if it is the angle, the strategy, but even perhaps the case. But I have the possibility, I will have the possibility to utter some words about that, about the rest of the point for this conference. Thank you very much. I just think that Mr. Aguinier would like to add something. Thank you very much.
Thank you, Mr. Jolson. Good morning, Your Honors. Just by way of example on specific points of the Rule 103 disclosure, Your Honor, just to remind everyone and put on the record that the deadline that was put by the pretrial judge for the completion of all disclosure obligations is the 27th of May. And after that, we received a number of notices of additional exculpatory disclosures. And to give an example to Your Honors on the impact of these late disclosures, referring to the paragraph 12, and I shall not mention the pseudonym of the witness because we are in public session, but specifically on this disclosure 87, the prosecutor says that the information is known to the defense. This is in fact not entirely true, and we have a couple of examples where we received this disclosure last Friday and we acquired information for which we have sent correspondence to the SPO requesting this information to enable us with the addition of a witness to explore certain information and make investigations, for which we received negative responses. And last Friday, we received that information in exculpatory material. So all the time and resources we have put into trying to acquire this information ourselves. And to be honest with your honors, we were preparing motions about this information that would allow us to acquire further information, is a perfect example that when documents would have been disclosed on the 29th of July or shortly thereafter, as it is the rule under 103 to be immediate disclosure, it would have allowed the defense to gain a lot of time and direct its efforts towards an information that was otherwise available. This is by way of example. The same goes for the notice, 102.3. We had multiple additional notices. Is it really the time to make a final review when the deadline for this final review, and we have requested after those extra notices from the SPO to conduct this review, and they assured us that they are doing it and they have done it. Today, 108 documents coming into our hands will have to be analyzed, reassessed against what we know already from the case, and will engage further analysis and investigations. This is by way of example, the impact of late disclosures. Thank you, Your Honors.
Thank you, Defense Counsel. Yes. Mr. Prosecutor, I give you the floor for a reaction you will surely have.
Thank you, Your Honor. Your Honor, the prosecution case has not changed. We have decided to drop a couple of witnesses. It's entirely normal going to trial to focus the case more. I think it's also in the interest of a judicial economy to do that. With regard to the new documents that we have added, I think perhaps counsel is referring to the request to amend our Rule 102.1b list. Those would be the only documents that we would add to our case, to the presentation. And we requested addition, Your Honor, of 4 documents. One of them was already known to the defense. It had been disclosed, and we have explained the reasons why that now we want to, in fact, also disclose it under Rule 102.1b. 2 documents concern the witness that was added at the end of July. The prosecution has also explained that it probably does not intend to use these documents at trial, but disclose them, wants to add them to his exhibit list for completeness and just for fairness to the defense. And one last document there is a report of that is largely corroborative of information already known to the defense, and there is a photo board identification where a witness provides visual identification of people he had already identified among the alleged perpetrators of his abduction and mistreatment. We don't think that this adds much. In fact, the case, as I stated, did not change, and the number of documents added there is limited. With respect to Rule 102.3, of course, Your Honors, these are not documents that the prosecutor intends to use at trial. We gave notice to the defense because we are obliged to do so. The documents that are relevant, they're not necessarily all material to the preparation of the defense case, and when we receive, should they request their disclosure, we'll also make that assessment. And finally, with respect to the Rule 103, I am not sure what documents counsel was referring to, because it was rightly cautious not to mention the witness, but the documents that we have disclosed further to the addition of the July witness, it does take some time to review our records further to the addition of the witness and to locate the documents, Your Honor. It was also during it coincided with the summer recess, with there was less staff doing the review, but we have disclosed them as soon as we found them. We started processing them, and we have now disclosed them. I think this concludes my response to counsel.
Thank you, Mr. Prosecutor. Defense Counsel, we will do a further round. Let us divide. We have the amendment, the request for the amendment of the list of exhibits. I want to discuss that later on. To be clear, you were not discussing that, for my understanding.
No, Your Honor. We were discussing the disclosure of last Friday, disclosure 87. I can give you the year end.
No. That's clear. Just a small. So we are not discussing that, because I was under the impression that yes, Mr. Prosecutor was asking that. So for me now, it's important to state that you oppose to the SPO adding the 85 not 108, 85 documents. Am I right? 85 documents to the Rule 102, Paragraph 3 notice, even if they could be material for your defense. Is that your position?
This is not the position, Your Honors, because what is relevant for us, we have to look at it and we have to investigate. Now, our submission on that point of the notice was that this is too late to engage anew, reassess what we received, and re-engage and reassess our analysis and investigations. So it's the prejudice resulting from the delay that after 18 months we receive another notice where the review should have been done by the 27th of May. That is the notice submissions. The exonerated material, that we are not saying that we should not receive those notices, because it's relevant to us. But we are put in a position where we have to deal with it later than we should have. What we are saying is that we should have received this notice, and this review should have been conducted before the transmission to the trial panel to allow us to be more certain about what is in the case and what we should explore as a matter of priority and interest to the defense. That is the notice submissions. The other submission is the exonerated material, for which we have requested some information, and the submission of the SPO, with all due respect, is not entirely accurate. That all the information is something that is known to the defense. In fact, totally to the opposite. There were information that we sought from the SPO, and they responded that they did not have or could not give us, and then we received them this Friday. Thank you.
Okay, good. Yes, I see. I'm looking at. I can give one more round because I want to make everything clear and not leave it in the air. It's not clear for us yet if we will have an oral order or this, or that we will give you a written decision on this point. But I will allow Mr. Prosecutor to give a reply to what the defense has said, and then I will give the floor to the defense.
Yes, just briefly, Your Honor, thank you very much. First of all, when it comes to prejudice, we don't agree that, prejudice needs to be shown. So if the defense, further to the review of the materials, if we will be allowed to issue this updated relevance list, if the defense then finds specific documents disclosure which is prejudicial to them, then they can make submissions about that, and we will respond. So I think it's early and premature to talk about prejudice, and we reject the submission on that point. We also, with regard to the Rule 103 disclosure, it's really difficult to respond now because I'm not clear about the nature of the information the Council is talking about. What I want to say is that we stated that the information that we provided to them, the information disclosed in the Rule 103 documents with regard to one witness, and I'm not sure it's the same witness that the defense is talking about now, was largely known to the defense, not entirely known to it. But I'm also uncertain as to whether we are actually talking about the same witness. It's difficult to continue this discussion in the abstract, Your Honor.
We will go into a private session because I want to have this sorted out and to make it clear, because either way, if we have to do an oral order or we have to give a decision in writing, I must know where you both stand. So, Madam Court Officer, could you bring us into private, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer. You have the floor, Defense Counsel.
Thank you very much, Mr. President. So, about this notice, it's a difficult situation for us. There are rules and there are delays. And we know perfectly well where the prosecutor is out of time for this notice. That's sure. What we ask for is really to ask you to guarantee our effective right of defense. That's always the same thing with the right of defense. The defenders, the pleaders, the lawyers use of always this argument. But this is really a problem of effectiveness in our use of our rights. I explain you, of course, the real prejudice we have. We don't have time to deal with some documents now. It's too late. What we are asking for is to have a guarantee of the primacy of the law. That's really the point. I hear my dear colleague to say it's premature to talk about a prejudice. This case is in investigation since more than 20 years, please. The choice of the prosecutor is to issue an indictment 18 months ago. And we are always, that's the nature of the procedure, late. That's why a pre-trial proceeding has been set up. And now it's enough. We have to deal and to go to trial with a case that everybody knows, and not to add some document accepting new documents.
Defense Counsel, I'm going to interrupt you. You made your point, and I've heard you. If there's a new argument we should consider in this respect, I will give you the floor for that.
I understand it.
Yeah?
Perfectly well. But I think you understand perfectly well. This is the point. I just wanted to underline it. So thank you very much.
Go to the next point, and we leave pending the point of especially from the SPO, and you will be able to respond on this point as soon as the SPO will have come back with this further information. Then we turn to the defense. Yes, we asked submissions on Defense Counsel on your further investigations. We noted that they have not been completed, are currently ongoing, and that you will have to go. We asked whether you could anticipate disclosing additional evidence. And I would like to know. I would like to know from the defense if there are additional observations. We will, of course, be discussing part of this during the ex parte hearing if you choose to do so. However, whatever you can share in public session, it has our preference, but with all the restrictions and limitations that are inherent to your investigations. So, Defense Counsel, the floor is yours, and I will be coming back to specific parts of your preparation at several moments today.
So, of course, Mrs. President, Your Honors, I have to be very careful on such a point. That's sure. That's sure. I just can say in public, and I want to say it in public, it's very difficult for us to provide you effective information about that at a moment when the prosecutor didn't finish his own disclosure, of course. So, in public, I think that's all the information I could provide you, I say in public. Thank you.
And is there information you could share with us in a private session, but with all of us here present? Okay, then we go, because the ex parte hearing, I would like to reserve it for subjects really that should be discussed only with the panel and nobody else present.
I think it's better. Thank you very
So
much.
then we go into private session. Madam Court Officer, could you kindly bring us into private session? Counsel,
Your Honors, we're in public session.
yeah, more generally speaking, let us stick to the agenda. That is what I think is important to do. Yes, next point. We requested your submissions on the adoption of a framework governing the handling of confidential information during investigations and contacts with witnesses, taking into account Defense Counsel.
Apologies to interrupt. On the agenda, Your Honor, I think we didn't hear the SPO speak about his point on the agenda on the investigations and their completeness, and they moved directly to the Rule 102 and 103, and I believe it's important for the record that they mention at which stage, if there are any information about their investigations. Apologies again for interrupting you.
Please, I did. We asked submissions from both the parties and the Victims' Council, and also we requested information from the registry on specific points. And what the panel is doing now is discussing topics we think that we need to proceed with the case. And I noted, and I think that is public, that is paragraph 3 of filing 303. The SPO considers its investigation to be completed. Investigations would be limited to clarifying facts already disclosed to the defense. And then we moved to the two specific points regarding 103, Rule 103 and Rule 102, paragraph 3. So in the view of the panel, there was no need to ask the SPO if there are further investigations, because I have it black on white that they are not doing further investigations. But for the defense, and I can ask the question out loud here in the court again, but this is the remarks we got from the SPO. Mr. Prosecutor, is there something you would like to comment on this?
No, that's correct, Your Honor. We didn't make any submissions because we didn't understand the panel needed further submissions on this issue. In the paragraphs 2 and 3 of our submissions, as Your Honor has specified, we have completed our investigations with the caveat that we are assessing, as Your Honor has recalled, whether the need for limited final investigative steps may be necessary for clarification purposes, but that is all. That is what is in our written submissions,
yes,
Your
that's
Honor.
what I saw, but then what can we expect? Then that's what I then ask you. Is there something to expect?
Well, Your Honor,
it's an open question. I don't know. But if you say that finalizing investigations, then
Your Honor, well, of course, as per our office's mandate under Article 35 of the Kosovo Specialist Chambers Law, the SPO continues conducting its investigation. It's a continuous obligation. We are also aware of the fact that to introduce new evidence after the trial is started, the rules set a specific framework, judicial authorization is required, and we'll of course follow the procedure set forth in the rules if we indeed investigate and gather additional relevant evidence. Now, with regard to examples of what we might be investigating, Your Honor, could we perhaps briefly move into private session as we discuss the nature of these investigations?
very well. Yes, Madam Court Officer, could you bring us into private session, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer. Yes, point F. I was halfway my sentence. We have requested submissions with regard to this framework governing the handling of confidential information during investigations and contact with witnesses, which is also available in another case. And we requested, we note that there is a disagreement between the parties on this point. I noted that the SPO is in favor of such a framework, and the defense does not consider it necessary at this stage. And I noted that the SPO is of the view that the framework already adopted should mutatis mutandis be adopted for the witnesses in this case, and also for the witnesses who are subject to the SPO's request in filing 261, and that the defense does not consider it necessary to adopt such a framework. And they noted that there is an inter partes agreement on this matter. And I noted that the Victims' Council has put on record his full support for this framework. The question from the panel is for now if we could receive, if that is available in written form, a copy of this inter partes agreement on contacting the witnesses and victims, as well as persons privately interviewed by the SPO. Defense Counsel.
Thank you, Your Honor. There is no such written agreement. It's more of a gentleman agreement because of the size of the case, the number of the witnesses. We came to the SPO in the beginning of the case, asking how should we approach any of their witnesses or the people listed in their witness list or people they have interviewed. And we agreed that we come to them first if we need to speak to them. And they agreed to that. With the exception of protected witnesses. They can correct me if I'm wrong. And we have done that for one particular witness without any difficulties through Mr. Prosecutor, who gave us the contact details and was informed of our wish and generally speaking what we wanted to do. This is more objectively about some locations that we needed to visit. I think you will understand what we are talking about. We have also approached the SPO to get in contact with one person that is not on the witness list, and they provided us with their contact details and asked this witness if he wanted to meet the defense, for which the witness refused, and we didn't have any contact with that person. And we believe with regard to the size and the number of the witnesses and also the intentions of the defense amongst the witnesses that are still alive, still available, and could be contacted by the defense, that the way we are proceeding on a case-by-case basis with the agreement, consent information, knowledge of the SPO is perfectly workable so far. And that this is why we believe there is no need to encumber the procedure with such a heavy framework. But we're open to discussion. If your honors wishes to discuss with the SPO based on this framework, something that would be more adapted to our case, we're open to it. We can come probably discuss it with the SPO and come with something that is joint. Or we can give the benefit of the practice that has been without problems, I believe, so far. We'll give it a chance because it's been working, and the intention of the defense is not to interview anymore. Maybe exceptionally, we can even inform the panel about it, and we can go on that basis, on a case-by-case, which would be maybe lighter. If your honors are in favor of more strict protocol, we're open to discussing it, come with either joint proposals or different arguments on both sides on how we should adapt this.
Thank you,
Thank you,
Defense Counsel. Mr. Prosecutor, do you have any further submissions or comments on this?
Yes, Your Honor, indeed, we did have an agreement with the defense, an oral agreement that they could contact witnesses who were not protected witnesses or victims in this case. And indeed, we have facilitated contacts for the defense during the investigative phase. However, as the proceedings move towards the trial phase, more information is disclosed, and also the risk of interferences with witnesses may increase as the, for example, scheduled testimony approaches. So at this stage, we consider that the decision adopted in the other case provides a workable framework for contacts with witnesses going forward. That's why we have expressed our view that from this stage on, in spite of we had an agreement with the defense as they stated, but from now on it would be appropriate to adopt the framework provided for in the Case 6 decision.
Thank you, Mr. Prosecutor. Victims' Counsel, you have the floor.
Your Honour, thank you. I won't repeat the submissions that I made in writing, expressing our support for the framework, but may I just add this. Defence Counsel is quite right that a gentleman's arrangement may work perfectly well in terms of giving one another notice of an intention to approach a witness, but the framework goes much further than that. The framework mandates the recording of any interview that is to take place between, in this example, Defence Counsel and the witness, and for the reasons that have been explained very fully in Case 6, we take the view that that is an important safeguard in a case of this kind. And so the informal procedure may work very well if one's not dealing with, for example, a dual status witness who has, shall we say, a complicated history, but we would say that in this case we would want the framework to be adopted as it has been in Case 6. If that's limited to dual status witnesses, then so be it. But we would want at least that protection, please. Thank you.
Thank you, Victims' Counsel. Defence Counsel, we already gave you, or I already gave you the floor because I had this specific question. Is there something you would like to add in this respect?
Thank you, Your Honor. Just to say that the recording, just coming on the specific point of interviewing witnesses, that is taking an interview or a statement, and this is one of the submissions we made. We don't have that intention, especially for the dual status victims. As Your Honors know, maybe we need to move to private session to give a little bit more information on that.
Madam Court Officer, could you kindly bring us into a private session, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer. We will take a break of half an hour. I kindly ask you to be back 5 minutes before 11, and then we will continue with the next topic, which will be the visit to the alleged crime site. I would like to hear your considerations on that topic. Very well, thank you. Hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. We will continue now till 12:30. That's the program for today, and then we will adjourn the hearing till tomorrow morning, 9:30. Good. Yes, next point on the agenda. The site visit, pursuant to Rule 74 of the rules. The SPO, the Victims' Council, and the Defense Council have given their observations. The parties and Victims' Council each consider that a crime visit could be of assistance to the panel. The SPO makes reference to other evidence that would similarly inform the panel about the location and the layout of the crime site. I noted that the defense requests a crime site visit, and the defense would propose multiple locations that should be visited. And I noted that the Victims' Council considers that a crime site visit could be highly beneficial to the trial panel, but, or not, maybe not a but while acknowledging that this benefit must be weighed against security and cost considerations. I will do a round with all of you, starting with the SPO. Do you have any additional clarifications or observations on this point that you would like to share with the panel on this matter? I see you nodding, please, Madam Prosecutor.
Yes, Your Honors. Thank you. Well, as explained in our written submissions, we do believe that a site visit will be of assistance to the panel. The SPO thinks that the best time, the most beneficial time to conduct such a visit would be at the end of the presentation of the evidence by the SPO, Victims' Council, and the defense. And this is so because by that time, the panel will be in a good position to have an understanding of the entire evidence presented in this case by all parties and participants, and will be best equipped in its observation of the site. However, Your Honors, we are mindful of a number of considerations connected with such a visit, including security, cost, and logistics. So in this regard, we, of course, leave this assessment to the registry, pursuant to the practice direction on site visit, and, of course, to any determination of the panel. We, however, believe that even if these considerations were to weigh against such a visit, the panel will be able to get a good understanding of the site through the evidence that the SPO will present and put forward during trial. Thank you very much.
Thank you, Madam Prosecutor. Victims' Council, I would like to give you the floor on this point too, and my specific question would be, because you referred to specific jurisprudence on this point, what this case makes it so special that we should go there?
I'm not going to make submissions that there's anything so special about this case that mandates the trial panel making this journey. That's not what we have sought to argue. We've drawn to your attention what we hope is some helpful commentary by other judges on the benefits of a site visit. And in particular, we hope helpfully, we've canvassed the views of the individual most directly affected by what went on there, who will be testifying in this case. And we've communicated to you his view, which is that he thinks it would certainly assist you. And it's fair to balance that by saying that even he acknowledges that there may be security implications for Your Honour and Your Honour's colleagues in so doing. So we've made our submissions, and I shan't repeat them here, and I hope that's clear.
Thank you, Victims' Counsel. Defense Counsel, the question of the panel, of the questions of the panel in this regard are somehow more specific, and for us the question arises if this can be done in public or we should go into private session, because my question would be a little bit more specific, what you, based on your submissions, what the exact topics and locations it is you think that would be clarified by such a visit.
So I think my answer could be in public, Johanna.
Okay, good.
So, as you know, we fully agree with the assistance and the utility of such a visit. It could not be of benefit for the court. It will be, that's sure. We were on the spot, and we have really a different view. When you have a view with the pictures, with the sketches and so on, it's not the same. A lot of things can be induced by this visit, I'm sure of that. For us, two issues are very important. Places that we could go to see, as you know, in the case, there is two other places that could be interesting to go, but we have the occasion to furnish some further observation about that, written observation if you want. And the other thing is the moment of the visit. We have the feeling the best is to hear the case of the prosecutor and then to go on the spot before the presentation of the case, of the defense case. That's what I have to say, in my opinion, in public, but I'm ready to try to answer to the question you could have.
Thank you, Defense Counsel. Yes, my question requires an answer. The answer to my question requires a little bit more of specificity. So I leave it to you to go into private session or to do it in the ex parte hearing, and have a preference, of course, for a private session, because I would like all the colleagues to share in your observations. But that I leave it to the defense.
Yes, I think we could be able to answer in public, I think so, when you stop me if...
In private, you mean?
I made some difficulty, but I think we can...
Yes?
We are able to explain it
Okay.
in public, I think
Okay,
so.
but because what I would like to know a little bit more, or not a little bit, I would like to more about what locations you think we should... Your answer, your observations for us are kind of general, and I would like to know where the specific problems are, because maybe if there are specific problems or specific points you would like us to discuss, we could also look, or you could look into, or maybe the SPO could look into alternatives that could also, assist the panel to get a better view of the location. Because, and it's rightly said so, there are different considerations we have to take on board, and one of them is also expediency, and a visit of this kind, and if it's necessary we do it, encompasses a lot of logistic and security issues,
Yes.
let alone the financial issues.
Yes, of course, the security issue is a huge issue, that's sure. But we have the feeling that if we want to be able to understand perfectly well the chain of command and who is who in this famous Cook's town, we do have, of course, to go on the former metal fabric of Cook's, but also we saw in the prosecutor's case, there is another place, a house, where the commander of Brigade 128 took place. And these people, the sure, has some contacts of, if we want to have a clear view of this situation, of the chain of command, it could be nice to see where is the house, the distance, and to have a lot of information about that. And it is the same with the cemetery. The cemetery, I don't have to to provide some more information. I'm sure you are aware about which cemetery I'm talking about, and in my opinion it could be very interesting to have a clear view with the distance, with the conditions and so on. Thank you.
Thank you, Defense Counsel. Very well. We go to the next topic. We conclude this one, the conduct of proceedings, which is point C. These are 7 items under C, and I will go through each of them in sequence. The first topic is the commencement of trial and the opening statements. We have received submissions by the parties and the Victims' Council on this point, A till F. I'm not going to read them all. They are sufficiently in the agenda, and for us, for the panel, it is important. Are there any additional steps that need to be finalized by the parties and participants in order for them to be prepared for the opening of the case and to give their opening statements? So that is a more limited formulation than to be ready to start with the different cases. But so yes, are there any additional steps that need to be finalized by the parties and participants in order for them to be prepared for the opening of the case and to give their opening statements? And yes, and then with regard to the defense, if I will give you the floor, I will start with the SPO. If you could try to be more specific on point E, so how much time the opening statement will require, and then I'm not talking about hours, but I would like to know if it's a morning or an afternoon of a whole day. And with regard to point F, if the several questions regarding the intention of the accused to make or not an unsworn statement. And if you don't know it yet, I would like to know by when you will know. Okay, we will first hear from the SPO. Mr. Prosecutor, Madam Prosecutor, you have the floor.
Thank you, Your Honors. We don't have any further submissions compared to what we submitted already in writing. With regard to the next steps you were asking about, the SPO will, and my colleagues will comment further on this later on, intend to file a motion for adjudicated facts and something concerning the admissibility of evidence. So I think this will be the next upcoming steps before the commencement of the trial. Other than that, we are ready to begin whenever a trial date is set. Thank you.
Counsel, you have the floor.
We will also be ready to begin whenever the trial panel orders that the trial should begin. And there's nothing that we need to do apart from finalising the details of our opening statement. But we'll be able to do that in good time for the start of the trial, whenever it is.
Thank you, Victims' Counsel. Now it's the turn for the defense. Defense Counsel, you have the floor.
Thank you very much. So the first thing I have to say, it's amazing to hear that the prosecutor is ready to start a trial and he doesn't finish his disclosure of the proof. So that's amazing to see, yes, we are ready, and they ask for a lot of things and with consequences for the defense. I don't have to go back to what I said at the beginning at the hearing at this moment about that. But that's sure, that's I consider very amazing because there is no need to oblige the defense to support or work with new element disclosed so lately and to say we are ready and the other one are not, of course. It depends on what we have to receive. That's the first point. The second one, of course, is yes, we have the intent to make some opening statements, and it depends, of course, of the time the prosecutor needs, because I suppose if he needs 2 hours, it seems it's almost 2 hours, we have a clear idea of what they want to talk about, and we have the intent to talk about 2. So 2 hours, it's enough, I think so. But I have a big concern about the time that legal representative, my dear colleague from the legal representative of victims, asked for 2 hours. It's a delicate question. In the internal procedure, the legal representatives are not parties. They have to explain their view and concern. 2 hours, I'm afraid, it could resemble to like the wish to be a prosecutor bis. And it cannot be question of that. I was legal representative of victims before the ICC in the very first case of the ICC. At the end of 3 years of trial, the panel provided me 30 minutes to explain the view and concern at the end of the trial. So when I hear the wish, I understand it, I fully understand it, the wish to have at the beginning, at the commencement of the trial, 2 hours, really, we have to be careful with that, and I would like to hear my dear colleague from the representation of victims about that. 2 hours, it's more than the time that the prosecutor himself asked for. So that's something very special, I think so. And on the third point, yes, Mr. Shala has the wish to make a statement. I don't know, it will be a short statement, but not a too long. That's sure. Thank you.
So he will give an unsworn statement. That is what you're saying now.
Yes, of course, Mrs.
Okay.
President. Yeah.
Very well. And the decision with regard to the duration of the opening statements is an issue which is, of course, in the hands of the trial panel to decide upon the amount of time that will be allocated. So it's not something that I further want to discuss here. I just want to hear from the parties and the Victims' Council what the duration is they intend. And I don't want to have a further discussion on that matter.
Okay, that's it. Thank you very much.
Very well. We will issue a decision in due time regarding the date for the commencement of the trial. We go to the second topic, and that is the familiarization of witnesses prior to testimony. We have received your respective observations on this issue. I will not give a summary on it. Yes. The trial panel would like to know if there are any further observations on the matter of the familiarization.
No further observations from the SPO. Thank you, Janos.
Thank you. Victims' Council?
Nothing from us, thank you.
And Defense Council?
Just to say, let's be clear and definitive about the fact that we are, of course, against witness proofing. That's the only thing I want to focus on. Thank you very much.
Okay. Thank you. The third item is the dual status witness victims. The SPO and the Victims' Council have been asked whether they have exchanged information, including with WIPSO, relevant to identify which participating victim is also an SPO witness. And we noted the SPO request to receive from Victims' Council a list of individuals holding this dual status. And we noted that the Victims' Council has no objection to provide a written list in order, that the matter is clear. And I also noted that the Victims' Council has no objection to the disclosure of this information to WIPSO. Is there something the SPO would like to say in this regard? Something to add?
No further submissions, thank you.
Okay, thank you. Victims' Counsel, is there something you would like to add?
Your Honour, only this, if the panel approves that course and gives its authorisation, we can do that today.
Okay. At the end of this hearing, I don't think it will be today, but that will be tomorrow. We will give some oral orders and maybe some directions depending on the need to give an oral order, and then we will clarify that point.
Thank you, Honour.
Yes, item 4, that is the presentation of evidence, also witness evidence. The SPO was requested to give some further information on this item. Due to the nature of this item, I would like to go into private session. Madam Court Officer, could you bring us into private session?
Your Honors, we're in public session.
Thank you, Madam Court Officer. Very well, Mr. Prosecutor. We note that you intend to submit expert evidence pertaining to a witness, an expert, and an institute, and we would like to receive clarifications as follows: through which procedure you intend to seek the admission of the transcripts of this witness interview in a previous case, if you intend to rely on the evidence of this witness as an expert witness, and why the person is not on your amended list of witnesses, and through which procedure you intend to seek the admission of the reports of the institutes and the other person. Once again, the panel notes that the experts who are are the authors of these reports are for the moment not on your amended witness list. And before giving you the floor, Mr. Prosecutor, the panel also recalls that Rule 149 of the rules foresees experts not to be called only if the parties are in agreement on that. And if there's no agreement, a report cannot be submitted without the expert being called to testify in court. You have the floor, Mr. Prosecutor.
Thanks, Your Honor. I'll try to address all the points raised by the court. As a first point, we propose this, to tender the expert reports pursuant to Rule 149 because we did not receive an objection pursuant to paragraph 2 of the rule within 7 days of their disclosure. Of course, we understand the panel still retains discretion to request the witness to appear. In that regard, we stand ready to call the witnesses to testify in court. We consider the witness for, just a second, Your Honor, I need to see the number, 4826 to be an expert witness, and its report, therefore, to be an expert report falling under Rule 149. We also consider the testimony given by this witness in another case to be essentially part of the same report and to qualify as an expert report because it's evidence given by an expert which relates directly to and comments upon the expert report. Therefore, we would seek admission of the same report under the same rule. The fact that the witness, the expert and the DNA expert are not on our witness list, we'd be happy to amend it if the court wishes us to do so. We, on consideration of our proposal to simply tender the reports, we have decided not to add them to the list as witnesses, but we have, of course, provided notice in our submissions that we will intend to rely on our evidence. But if the court has a preference for us to include them in our amended witness list, we're prepared to file a corrected version shortly. Is there anything else that I have failed to respond to, Your Honor, or does that address all the court's questions?
I think that essentially what I understood is that you say you are the SPO is ready to add the different witnesses as expert witnesses to the list of witnesses of the SPO in order to follow the procedure under 149 if the panel wants to have them in court. Is that what you're saying?
That's correct, Your Honor.
Okay. I noted that that is the position of the SPO. Yes, Defense Counsel, do you wish to respond?
So, I'm happy with the answer of the prosecutor. I don't know if there's something to add. Just one thing. Those reports will be part of the debate. And you are aware that we ask for some experts to see these reports. So there is a lot of things. That's why we insist, of course, to have a summon to the expert witnesses to come. And welcome for the new information. The prosecutor is ready to summon them. That's marvelous. Thank you very much.
Thank you, Defense Counsel. Mr. Prosecutor, is there something you would like to add?
Your Honor, not specifically. We will call the witnesses if the panel requests us to do so, but we maintain the position that tendering the expert reports would suffice and, in this regard. We also would like to add that proof of death of the victim, the prosecution will prove the death of the alleged victim irrespective of the tendering of the forensic evidence. That, of course, adds more elements for the panel to consider, but there will be other direct evidence of the death of the alleged victim in this case without relying on the expert report.
Okay. Thank you. Let us now return to other written submissions the panel received under the same item. Victims' Counsel was likewise requested to make submissions on presentation of evidence and the view and concerns of the victims participating in the proceedings. In addition to your written submissions, Victims' Counsel, the panel has the following questions. And please bear in mind that we are in public session, so please do indicate if you see the need to go into private session to elaborate on any of these questions. First, do you indicate at this stage to call any witnesses? That would be our first question. Could you clarify for what specific purpose the clinical psychologists specializing in trauma would be called? We have an idea, but I would like to have it more specific. Do you intend to present other expert reports with regard to harm allegedly suffered by victims participating in the proceedings? And this is not so much on evidence, but on another important topic in this, connected to these proceedings. Does Victims' Counsel intend to make request for reparations, including compensation, to be considered by the panel in case there is a conviction? And later on, we will discuss the question of referral to Kosovo courts or not, and also if we should do the proceedings, the reparation proceedings, if any, at the same time as the criminal proceedings. But for now, these are the questions I would like to pose to you, Victims' Counsel.
Thank you, Honor. May I take them in turn? The question, do we intend to call any witnesses? The answer that we have given at paragraph 17 of our written submissions is not intended to be unnecessarily cryptic, but the position is that the panel is going to hear evidence from many of the witnesses who would otherwise be relevant for us to call in the course of the prosecution case. And our view is that it is very unlikely that we will call additional lay witnesses, if I can call them that, non-experts, after the prosecution case has been heard. We may, as we've indicated, want to call one or more victim to present their views and concerns, but that obviously comes under a different category. The clinical psychologist that we have in mind is somebody who has testified in other international proceedings in relation to harm, and it's that topic that we would be focusing on, and that is in relation to one individual.
That was the information I was looking for. If
Yes.
it was specifically linked to one of the victims.
To one individual, and it's probably better if I don't specify at this stage which one it is, but it probably an informed guess is very likely to be correct on that score.
Thank you for this additional information.
Other expert reports, in addition to the psychologist, the answer is no. And whether we will make a request for reparations, including compensation, the answer is yes. We have obviously followed the proceedings in case 5, and we wondered whether it would be right for us to add to the list of topics for these hearings the issue of reparations, and we rather took the view that the panel was likely to be issuing guidance in respect of reparations anyway, and we thought it best to wait for that to come. So yes, we will, but it's obviously a largish topic which we can, I hope, find time to discuss later in the proceedings.
Thank you, Victims' Counsel, for the answers. Defense, would you like to comment on any of this?
Yes, Your Honor, thank you. As to the topic of the calling of witnesses, maybe the only remark we can make is that Your Honors will have to look at the dual status issue and the disclosure of the identities of victims to the defense. And as my learned colleague has said, I would say more basic than an educated guess would lead to the information that you need to be able to understand the extent. Obviously, what we can say in general is the defense is opposed to any duplication of evidence, but that will become clear. One issue that I will need to move to quickly is the presence of VPPs to present their views and concerns, and that's where the identity of those victims, which is an issue under your consideration by filings at the moment, and that's why I raised I'll probably, being in a public hearing, limit ourselves to the submissions that we filed yesterday that will be in your possession, to understand that this will not be practical if the identity of victims is not shown to the defense. As far as the experts, the clinical psychologists, of course we will wait to see the request and have a little bit more information to be able to take position. This is obviously tied to the issue of prejudice, harm, and potential reparations. So the framework and the guidance and the settings that you will establish, whether closer to what the ICC does or whether closer to what the STL does, that in the judgment you will issue to a certain extent conclusions on potential, if any, harm and prejudice that would be used at the national courts. That will be an issue that could guide us in taking the position to see the extent of the anticipated evidence and the appropriateness of the evidence, because this is the case of Mr. Shala, and it's the criminal proceedings that take the priority, and we are open to all relevant factors, but it has to remain the principle that any submissions from victim counsel should not put undue and excessive burden on the proceedings. Those are our submissions. Thank you.
Thank you, Victims' Counsel. With regard to the question of the panel on the expert reports with regard to the harm allegedly suffered by the victims participating in the proceedings, as we are I would like to make one remark on that. I did not mention it, that report in the framework of reparation proceedings, because it's still to decide how we are going to approach this issue. This is another case, and I first want to hear your views on that. So that's one point. But we used, it was presented in case 05 also for the criminal proceedings to establish whether or not there was harm, independently harm related to the alleged counts as they were presented to us in that case. So it's not only for reparation purposes, but also for the criminal proceedings. And that's the reason that in this framework I asked the question to the Victims' Council, but I do agree with you that it could also be of relevance, of course, for the possible reparation proceedings. So, and therefore that question came before the question if they will be asking for reparation. Just this to clarify that it has a double scope. That was my only point I wanted to make. Victims' Council, is there anything that you would like to add in addition to or in reaction to what the Defense Council has said?
No, thank you.
Okay, good. No, your points are duly noted. Defense Council, you were requested to provide further and more specific information regarding your defense case. You confirmed that you would present, of course, a case. I would like to know some more, but that we decided that we will do that in the ex parte hearing. So I leave it for now. Yes, we go to point 5, which is the order of appearances and issues related to the questioning of witnesses. Yes. Now, yeah, I had a question if the witness list is final and the modality of the witness testimony with regard to, this is a question for the SPO. I would say that part of an answer has already been given in the sense, I understood that it was final, but we are, it's depending on the expert witnesses if it would be final. But I leave the floor to you instead of giving the answer for you, Mr. Prosecutor.
Your Honor, your understanding is correct. There is one further submission we need to make, is that we have proposed to hear the evidence of our witnesses live, with the exception that we mentioned earlier on, and that we be ready to make submissions if so required, although that is also a live way of testimony. However, further to recent communication with some of our witnesses, it is possible that the SPO will seek, pursuant to Rule 144, to hear the testimony of one or more of them through a video conference link, as provided for by the rules. So this is the update I wanted to give to the Chamber. We are still assessing the need for that, and we'll be prepared to provide a final answer on that matter in the foreseeable future soon.
Thank you, Mr. Prosecutor. And one question more. Can you confirm that the order of the witnesses on the list of witnesses is the order the SPO intends to call these witnesses?
Your Honor, to the extent that that confirmation can be given at this stage, yes, I do.
Okay, okay.
But of course, as we anticipated in our submissions, there is always the possibility of some adjustments being required.
Yes, it's good that you mention it, but it goes without saying, just to see the type of, from the order, the panel can also deduct, and it also helps with planning issues. Do you have any further observations? No?
No, thank you, Your Honor.
Okay. With regard to item 5, does the Victims' Council have any submissions, further submissions?
Nothing further, thank you, Your Honor.
Okay, very well. And yes. Yeah, for the defense, I will ask you to give some further submissions if you have them on this point. And from what we have been discussing, an order of witnesses is too early. Do I understand that rightly, or is the order you have presented on your provisional list an order you think will stand?
Thank you, Your Honor. You have correctly understood that it is completely premature for us. We will keep contacts.
Yes.
The aim is to furnish this list and then see the order. I think we're far away from that moment, and we'll be more and more informed as time goes. But one submission maybe on the order and the modalities of presentation of the witnesses from the SPO. If you wish to hear us on this matter, Yes. We have strong and categorical oppositions to at least one modality. I would say the Rule 154. I'll say no more. Way of presenting witness evidence. And this goes back to the theme. I'll try to be careful, Your Honor, to be able to make the submissions in public. It goes to the general theme that Mr. Gillissen has presented from the beginning of the hearing, that we will make, of course, written submissions about this, but we believe that this is a sort of a preliminary or important question that we have to discuss and rule on before we go into trial, and to know on which basis we are advancing. This has a huge impact on the defense preparations, the withdrawal of those witnesses, the change in the modality of presentation of witness have a huge impact on the way the defense has proceeded for several weeks and months in order to prepare its defense and the modality of the presentation of its defense. If you wish more details, if you wish for more details, we can give them, but only in private session, Your Honor. But the general point is you will have to look at the particular circumstances of each individual witness in order to determine what is best for the interests of the justice in terms of the modality of hearing that evidence, either compared to the general case and also the availability of evidence on certain topics.
Defense Counsel, I propose that in order for you to be more specific, because I understand your general point, we can go into private and then you can, in a concise way, give your observations. What I prefer not to have is a concrete going into details, because really it's not the moment now. But I am interested to hear your observations with regard to modalities without getting too concrete, because we are not there yet.
Yes.
Madam Court Officer, could you bring us into private, please?
Your Honors, we're in public session.
Thank you, Madam Court Officer. Okay, point 6, it's on non-oral evidence. I note, or the panel notes, the SPO's intention to object to admissibility of 3 items should the defense seek to submit them into evidence pursuant to Rule 138 of the rules. We also note that we did not receive written submissions from the SPO on the question as to whether, taking into account the practice in case 05, the admissibility of non-oral evidence should be decided at the time of its submission at trial, or whether it can be deferred to the judgment. We would like to hear your position in this regard. We noted that the Victims' Counsel does not object to any of the non-oral evidence and has no opposition to the adoption of the decision on the submission and admissibility of evidence from case 05. And we noted that the defense will object to the admissibility of non-oral evidence disclosed by the SPO under Rule 102 of the rules. And we were referred to the previous submissions in this regard. And we also noted that the defense submits that it objects to a system as provided for in the decision on the submission and admissibility of evidence in case 05. We have noted your positions. We have taken due notice of that, with the exception of the SPO. I invite the parties and the Victims' Counsel, if necessary, to give additional observations. Mr. or Madam Prosecutor. Madam Prosecutor, you have the floor.
Thank you, Your Honors. And apologies for our oversight not to take position on the question of the point in time in the proceedings when admissibility of the oral evidence should be decided on. The SPO remains of the position that the admissibility of the oral evidence should be decided at the time of its submission at trial, rather than defer such decision to the judgment in terms of the actual process. The SPO defers to the panel's previous practice set out in the decision on the submission and the admissibility of evidence in case 5. With regard to the objection to admissibility of non-oral evidence, we don't have any additions to our written submissions. Thank you.
Thank you. For the defense team, do you need some time to confer? Because it's a kind of disturbing to hear voices on my left-hand side, so please. Yes, Victims' Counsel, would you like to add anything in this regard?
We have nothing to add on this topic, thank you.
Okay. Defense Counsel, do you have additional observations as to the one you provided to the panel in your submissions?
Not really, Your Honor. The main point is that we have a strong preference that admissibility rulings come on an ongoing basis during the trial, so we know at the time we make our final submissions what is in the evidence that we need to respond to. Exactly. Thank you, Your Honor.
Thank you. Point 7, which is judicial notice of adjudicated facts under Rule 157, paragraph 2 of the rules. And the panel took notice of the position of the parties in their written submissions. Are there any further comments by the SPO or the defense? And if not, we will go to the next item on the agenda. Mr. Prosecutor?
No further submissions on that. Thank you.
Okay, thank you, Madam Prosecutor. Defense, do you have any submissions in this regard?
No, Mrs. President, nothing.
No? Okay, thank you. Then these were the issues set out in the decision on the trial preparation conferences for the general agenda. There is one more point I would like to discuss, and that is with the Victims' Counsel and the defense. It is the following. We recall that in case 05, the panel has decided to conduct the reparation proceedings in parallel with the criminal proceedings. And the panel has also decided that in case of a conviction, it will not refer victims to civil litigation in Kosovo pursuant to Article 22, Paragraph 9 of the law and Rule 167 of the rules. But in that case, in case of a conviction, it will issue a reparation order pursuant to Article 22, Paragraph 8 and Article 44, Paragraph 6 of the law. And the relevant filing is 310 in case 05 redacted. We intend to follow the same approach in the present case. However, we would like to receive observations from the Defense and Victims' Counsel on this matter. Victims' Counsel, do you wish to make observations at this point, or do you prefer to file written submissions? And the same goes for later on the Defense Counsel.
We would very much prefer to file written submissions, please. Thank you.
Very well, thank you. Defense Counsel, the same question for you. Do you want to make observations at this point in time, or would you like to make them in writing? Like
I fully agree with my colleagues. Thank you very much.
Good. There is one other point raised by the Victims' Counsel that should be discussed here. Yes, you requested, Victims' Counsel, the trial panel to consider whether it is appropriate for you to be invited to any part of the ex parte closed session with the SPO, WIPSO and the registry, if such discussion will involve arrangements for dual status witnesses. We carefully examined your submissions, and we are of the view that the nature of the discussion with the defense is such that it does not necessitate the presence of the Victims' Counsel during any part of the ex parte hearing. So that was our view.
Thank you, so be it.
Okay. Very well. At this point, I would like to ask the parties and the Victims' Counsel whether they have other issues that they would like to raise with the panel.
Your Honor, briefly, I just would like to get back to that, to the panel with that answer that I did not provide earlier about disclosure and some remarks made by Defense Counsel. And
yes, you will be given the floor. In general, there is an outstanding point still, but because I'm looking at the time, tomorrow we will be giving oral orders. The point that is still left to discussion, which was done in private session, that can be done also tomorrow morning. So I say to the defense that we can postpone that to tomorrow morning. But yes, you have to.
So should I proceed now with this?
Well, if you can proceed, then you have the floor. But I wanted to stress that we prefer completeness over.
Yes. No, just I'll be brief, and also just for the sake of having the record completely straight. I will do this in a public session. We don't need to go into private. Page 17, line 19 and 21 of the provisional transcript. Today, Defense Counsel stated that they saw the information from us, and we responded that we did not have it. But then we received this information this Friday. I think that referring to the disclosure we did on Friday, the 14th of October. And for further information on the issue, Your Honor, in private session, it was discussed at page 19, lines 12 to 18 of the provisional transcript. I think that here Defense Counsel may have inadvertently conflated two different issues and two different requests, with the risk that it may have sounded as if we had stated that we did not have certain exculpatory information, but then we provided it. On 24 August, Your Honor, 2022, the defense asked if we were in possession of any criminal record with respect to the witness that we have discussed in private session. We responded that we would review our database, and should we find any such record, we would disclose it. The defense followed up on the 6th of October, asking how the review was going, and we responded the review was completed, and we would be disclosing the records they requested shortly. We did so on the 14th of October. A different request was emailed to us by the defense on the 22nd of September, where they requested the name of the country of residence of that witness, to which, rightly, we responded that we were not in a position to provide that information. That is also because we don't do that without the consent of the witness, and there were also issues of protective measures issued by a previous institution, the extent of which, to the extent, and we were not clear as to whether that was an information we could provide. So I just wanted to make it clear, the information that we said we could not provide was concerned the country of residence of that witness. The information of exculpatory nature was disclosed to the defense after completion of our review.
Defense counsel, are you in a position to reply now?
Certainly, Your Honor, and apologies for our mistake. Now we said they're not in a position. They were not in a position, not in a possession of the document. They were not in a position to give us this information, and we request that information also during an informal meeting with the SPO. Our submission was about the impact of receiving an information on the conduct of our investigations. We're not suggesting any inappropriate behavior on the SPO on this particular issue, and we are sorry if they understood it that way, but we were given an example of a piece of information on one document because we were looking at those kind of disclosures, their impact for one single document or a piece of information on what we engage in time and resources. Thank you.
I understood your submissions in that way. Thank you. So no further submissions from the part of the SPO. Thank you. Victims' Counsel.
May I raise one matter that's arisen today, and I'm not suggesting that it necessarily needs to be resolved today, but it may be useful for it to be on the agenda for resolution at some stage. And it's this. It goes back to something that Defence Counsel said in the context of my request for time for my opening. Just to have it clear, I've in fact said that it'll take not more than 2 hours. I can't say precisely how long it's going to be, but I've given an outside limit. And Mr. Gillison's discomfort at the prospect of Victims' Counsel making an opening of that length prompts me to raise the issue of the content of my opening. And it may be that it's useful for us to have that resolved before I find myself, shall we say, making an opening that causes Mr. Gillison even further discomfort than he already has. And what I mean by that is that it may be useful for us to discuss that in the light of the decision on victims' procedural rights during trial that this trial panel issued in case 05, and for the record it's F00152, and it may be that we would both benefit from looking at that decision and perhaps returning to this topic tomorrow. But so I raise it at this stage because, let me be clear about it, in the very particular context of this case, I do intend to address the panel in my opening on matters that bear upon the issue of guilt or innocence, and I shall be doing that for what we submit are very good reasons and consistent, we say, with the decision that's been issued in case 5. So we're going to benefit from having resolved that before the day comes. I'm not saying we do it now, but I'm saying we should have it in our minds. Thank you.
Thank you, Victims' Counsel. In due time, this panel will issue a decision on the rights of the victims participating in the trial proceedings, and we will clearly set out what we think could be addressed in also the opening statements. So I don't intend in principle to have a discussion on that matter. Our guidance on that matter will be clear, and then I leave it to the Victims' Council to adhere to the instructions of the panel, which we will be in time if it, and I don't think that any of that matter will happen, but if in court it seems that it goes otherwise, then we can always mention it. But I think that our instructions on that matter will be clear, and I don't think it's necessary to discuss the content in court. But I see it as instruction for the panel, as or for the panel to be even maybe more clear than we already think we have been in our decision.
Yes, I intend it more as a courtesy to Mr. Gilson, in fact, to be transparent about what I intend to do. And of course, if the panel's directions to me are not consistent with my plans, of course I will change them. But as I've read the decision in Case 5 and having seen the way in which Victims' Council addressed the panel both in opening and in closing in Case 5, my current view is that what I propose to do is entirely in keeping with that. So I'm not suggesting that we have a discussion about the details of the content, but I've given, I hope, fair notice of what I regard as the proper scope of that address. Thank you.
Thank you, Victims' Council. Your position is clear. Defense Counsel, is there something you would like to raise with the panel at this moment in time?
Mrs. President, with your explanation, of course, I have nothing to add. Thank you very much.
The parties and the Victims' Council can indicate to the trial panel in writing if they think other preparation conferences in the near future are necessary before the beginning of the trial. So you can always file a request of that kind. Very well. We were scheduled to continue today till 12:30. What we will do is I will set out for tomorrow what we are going to do. Tomorrow we will get back to a part of what we were not able to discuss today. And because we did it in private session, I don't mention the content, but we are all aware what that was. And the panel will give some oral orders, and we will give you an overview of some of the important decisions we think we will be issuing before in the near future. And if any other topic rises in this afternoon, we will discuss that further tomorrow. Because the important scope is that everything that needs to be discussed is discussed in these days. Okay, very well. I thank the parties and the Victims' Council and the registry, who has been present but has not received the floor for their attendance. I thank the interpreters for their interpretation, and our stenographer, and the audiovisual technicians, and the security for their assistance. The hearing is adjourned.
All rise.